Jamie Cottingham present? On the record in the matter of the people of the state of Michigan versus Jamie Renee Cottingham, file number 24-00899 SM, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee appearing on behalf of Jamie Cottingham.
If there was a date and time that was scheduled for a pretrial or final pretrial, that is for an assault and battery. Was previously no offer extended, and that's still the case.
For Ms. Cottingham, no, the offer that was extended was for Ms. Cottingham to plead guilty to an amended count 1 domestic violence with 76948 eligible. However, the necessary witness has failed to appear this morning and people are unable to proceed to trial.
I have a bond violation here. Right. Did you get a copy of the report for the bond violation?
Didn't either.
Okay, make sure you get a copy of it. It's dated April 7th, 2024. Allegations from the police report is that the protected party, who is a long haul trucker and on the road, allegedly received contact by the accused brother with threats, and also received messages from the accused sister via Facebook. I would like the prosecutor to retrieve that evidence, arraign you on a bond violation. Bond violation is a contempt of court order. If you're found to be in violation of the order set by the court as to your bond, you're subject to a penalty of 93 days in jail and or a fine of $7,500, okay? So the allegations are that you violated your bond by making indirect and direct communication with the protected party. I think the report also states that there was direct communication between you and the alleged victim. So you have the right to have a contested hearing. You have the right to be by your attorney at that hearing. I've advised you of the maximum penalty if found to be in violation of your conditions of release. Do you have any questions about that?
No, Your Honor.
How does your client want to proceed? Well, you haven't received the report. I'll go ahead and enter a plea of not guilty. We'll get you a copy of the report. We'll make sure that one's forwarded to you as well as the prosecutor. And the prosecutor will make arrangements to get in contact with the alleged victim. There is information in the report that includes both an email and a mobile phone number. That also indicates that the victim is a truck driver. So I will require the prosecutor to let us know if the date we set conflicts with that within a reasonable time frame. And you can reset the pretrial. June 18th. June 18th at 8 a.m. in person at the court.
Your Honor, so does this mean that the complaining victim will have another opportunity to appear then?
Absolutely.
Okay. I have another question, Your Honor. My client needs access to the home. She has personal property there that our understanding is in danger of being thrown away because the complaining witness has forwarded notification that he will be leaving the premises within the next couple of weeks.
Forwarded notification to who?
My sister, honey.
And I have no contact.
Where's the notification?
She sent me an email.
I need to see it.
Okay. Forwarded the email to you and Ms. Nash.
Okay, I will go off the record and I'll review that when I get a chance. You can have a seat now. On the record in the matter of the people of the state of Michigan versus Joseph Ellen Boss, file number 23-03399 and 24-00062. Council appearance, please.
Assistant Prosecutor Pacer Trustee on behalf of the people.
Assistant Public Defender John Lee on behalf of Joseph Ellen Moss.
Okay, today was the date and the time set for final pre-trials on both matters. How we proceed?
It's my understanding that Mr. Ellenboss will be accepting the offer that our office sent to him. The offer is for Mr. Ellenboss to plead guilty as charged to malicious destruction of personal property less than $200 in file number 23-03399 and agree to pay restitution totaling $846.54 and forfeit the firearm. And we would dismiss case number 24-00062. And I have a plea sheet and a restitution sheet here.
Okay, I have an advice of rights and plea information sheet present and the plea sheet. You heard the offer that was extended, Mr. Ellenboss.
Yes, Your Honor.
You want to accept that offer?
Yes, I am.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Okay, did you read this document?
Yes, Your Honor.
That's your signature?
Yes.
You understand all the rights listed here?
Yes, I do.
You want to give up all of these rights?
Yes, Your Honor.
So you have the right to the presumption of innocence. You're innocent until proven guilty. You understand that?
Yes.
You want to give up your right to be proven guilty?
Yes, Your Honor.
You have the right to see, hear, or question any other witnesses that the prosecution intends to call against you. You have the right to remain silent at trial, not have trial silence at your trial be used against you. Or you can waive your silence and testify at your trial, or you can subpoena witnesses to trial to testify on your behalf. But and also present evidence that you believe show a defense to the charges being brought against you. So you want to give up all of those rights as well as your right to a jury trial, correct?
Yes, Your Honor.
Anybody threatening you to get you to give up those rights?
No, Your Honor.
Has there been any promises made in exchange for you entering a guilty plea today?
No.
Are you currently on probation or on parole?
I am currently on probation
Out of what court?
from this court, Your
What judge?
You.
Until when?
Honor. It is a 12-month probation. It began last month. I cannot recall the exact date.
To 12 months.
In regard to an OWI tool, Your Honor.
Okay, and you understand that a guilty plea, and this could result in impact to any travel or immigration status that you may be seeking in the future.
Yes, Your Honor.
It also could be a conviction that you may need to report to your current employer, or you may need to put this conviction on a future job application.
Standing.
As to count one of malicious destruction of personal property less than 200, how do you plead?
Guilty, Your Honor.
you're agreeing to forfeit a firearm not related to this charge, but related to file number 24-00062.
No, yes, Your Honor. The police department already has that firearm.
I recognize they're in custody, but you were agreeing to forfeit it,
Yes,
correct?
yes,
Okay, and then you also are agreeing to pay a restitution in the amount of $846.54.
yes, Your Honor.
Okay. Got that, your basis, please.
Thank you, Your Honor. Mr. Ellenboss, on or about October October 8th of 2023, were you at 122 South Hosmer here in the city of Lansing?
Yes,
And that's in Ingham County, correct?
yes,
And did you at that time scratch and damage a truck belonging to Hunter Man Docking?
yes.
No further question.
Any questions from the prosecution?
And when you damaged that vehicle, you did that on purpose, correct?
Yeah.
No further questions.
And the amount of the destruction or injury was less than $200?
Yes.
The court is satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. You can make allocution. Actually, is the victim here?
The victim is here. He's out in the hallway. Can I get him?
Yes,
please?
please.
Yeah. And this is Mr. Mandocking. So
Okay, is he gonna give a statement at all?
I wasn't sure if you wanted to or not. I know typically you do defense first and then station. So
Okay, you can make allocation.
Okay. Mr. Ellenboss is currently at Holden House, Your Honor. He has been dealing with substance abuse issues that were aggravated by the divorce that he was going through, found himself in a position where he was homeless. It's actually a large part of the reason that him and Mr. Mandocking came into contact. He was crashing there for a minute. Mr. Ellenboss does not at all deny that he is culpable in this event, that he has made several mistakes during this period of his life. That's why he is in recovery. That's why he has plans to move to a three-quarter house after that and be gainfully employed and a functional member of society, as he at one time was. But he admits that he has issues that need to be dealt with, and he is in the process of dealing with those, and ask the court just to consider that in whatever sentencing the court determines is appropriate.
and the victim in this matter doesn't wish to make a statement.
I decided to move to immediate sentencing because I just put this gentleman on probation of less than a month ago, or about a month ago, before this court. He'll be on probation under my supervision for the next year. So it's not meaningful for me to send him to have another pre-sentence report, because it's not going to be much different from the last one I just had, and I can't duplicate his supervision before me. So your order would obviously be to continue in your probation and to not violate my order. You're going to forfeit your firearm as part of this plea agreement, that you're going to pay restitution to the victim in the amount of $846.54. You're going to pay a court fine in the amount of $300 plus $75 crime victim rights, $50 state minimum costs. And I recognize you are currently at the Holding House, but you're going to be looking for some employment because you got some bills to pay.
Yep.
Understand that?
Yes, Your Honor. I am already set and accepted at a three-quarter house as soon as my completion of Holden House is done. That's definitely going to be something that I'm going to be doing as soon as I'm able to.
So 425 and court cost was 846.54. It's a total of $1,271.54. How long are you gonna be in Holden House?
At least that is to be determined. I'm already accepted and I have a bed waiting for me at the three-quarter house. The staff there is discussing whether or not they're going to be doing my completion early and allowing me to move on, or if they're going to be holding me for, or continuing to treat me for the full 90 days. The full 90 days would be up at the beginning of July. But they have to discuss whether or not they're going to be completing me early sometime this week.
Okay, when do you think you're going to begin making payments on this?
As soon as I am able, at the latest, it would be after I am able to get a job at the three-quarter house, beginning of August. They generally don't like you to get a job as soon as you get into three-quarter housing. It takes some time to settle into things.
I'm gonna note here that you're gonna begin making payments by August 15th. You'll contact the court, and obviously if you're under court supervision, it's another file. So we'll be in contact with you with a show cause if you don't notify us by August 15th of any arrangements that you need made, okay?
Of course, yeah.
Okay. Any additional matters for the record today?
Nothing from the people.
Nothing for the defense.
Thank you. And let's see here. That's for that file. So that's being dismissed. You're all set, sir. On the record in the matter of the people of the state of Michigan versus Tiana Lillard, file number 24-00485. Council appearance.
Assistant Prosecutor Peter Petrowski on behalf of the people.
Morning, Your Honor. Joseph Yang on behalf of Ms. Lilliard, who is president to my left, not my right. Sorry.
No problem. Okay, how are you, ma'am?
Yeah.
I'm well, thank you. Today, date and time set for a final pretrial. The necessary witnesses failed to appear. The people are moving to dismiss this case, but they are objecting to destruction of your arrest records under the statute. So they do have the right to reissue this charge against you. Do you understand that? Do you have any questions about that?
What is the destruction part?
Well, your arrest records would include your fingerprints and the fact that you were arrested. They don't want that destroyed, probably because they believe they're going to likely reissue if they make contact with the victim that did not appear today. Do you have any other questions?
Yeah, we share a child together, so do I just not have any contact with him still?
The no contact order is over as me on this file, unless you have another one that I don't know about. This one is being dismissed today, so the no contact order is also going to be dismissed, but you need to wait at least 72 hours before you do anything that will cause the police to be involved, because we got to get that no contact order out of the system. So I'm not telling you that you can't have contact with him in the next 72 hours, but you want to definitely make sure there's no body misconstruing the contact as anything but peaceful, because that is still in the system until they take it out of the lien, okay? We'll get you a copy of the dismissal in just a moment. Any additional matters for the record?
Nothing from the people.
Nothing from the defense, Your Honor. Thank you.
Okay, you're all set, ma'am.
Thank you.
On the record in the matter of the people of the state of Michigan versus Lindsay Overbeck, file number 24-00310, council appearance.
Assistant Prosecutor Peter Petrowski on behalf of the people.
Jacob Riley on behalf of Ms. Overbeck.
How are you, Ms. Overbeck?
I'm good. How are you?
I'm doing well, thank you. Okay, today was the date and the time that was set for a final pretrial. But the necessary witnesses failed to appear. The people are moving to dismiss this case without prejudice. So the case will be dismissed, and you have the right, however, to reissue the charge against you, okay? Do you have any questions? Your copy of your dismissal, any additional matters for the record, counsel.
Nothing from the people.
Nothing from the defense, Your Honor.
On the record, in the matter of the people of the state of Michigan versus Makila Jaleesa Mead, file number is 24-00271. Parents.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Jacob Riley on behalf of Misdemeanor.
How are you, Ms. Mead? Good. Today is the date and time set for final pretrial. The necessary witnesses failed to appear. The people are moving to dismiss this without prejudice, but they are objecting to this destruction of your arrest records under the statute, okay? I can't hear you.
I said, okay.
Okay. Yes, you have a question?
I'm trying to, when you explained to her before, because I turned myself in, and this was a false.
I understand that, but that has nothing to do with why they're objecting to the destruction. I think it's pretty standard for any domestic or assaultive action right now.
And how long is that for?
How long is the destruction that they're, how long will you all be holding these records, or can she ever have them removed or sealed?
My apologies, I don't know that off the top of my head, but I can find out.
Valid question.
I mean, records like this stays on.
The fact that we have your arrest record, meaning you have a fingerprint and you've been arrested when charged with this, that's what they're objecting to at this time, to destroying that, but the case is dismissed. And they do, because it's dismissed without prejudice, meaning you've not been prosecuted for it, that means that they do have the right to reissue the charge. So if the complaining witness contacted them and said, I missed court, but I want to have my court date, they do have the authority to reissue that charge against you. That's what I mean about without prejudice, okay?
Sorry, the actual statute that the objection is under does not contain how long it is kept for. So
I would advise you to counsel with your attorney about what your recourse is when there is an objection to the destruction, because obviously they can only reissue the charge for the statutory time frame. So there's no reason why they need to hold these records indefinitely for you. I think after a reasonable time frame, you probably can make efforts or make a motion to them to destroy those records, okay? All right, and you can talk to him about how you would do that, because obviously you don't intend to stay in regular communication with him, I hope. And so get that information now so that at the time that's appropriate, you can submit that paperwork and they can make the destruction available to you, okay? Do you have any other questions at this time? We're gonna get you a copy of your dismissal, and then you're free to go. Thank you. I saw Mr. Cruz, but he might have stepped out. Okay, on the record in the matter, the people of the state of Michigan versus Cameron Jamil Fair. File number is 23-02131. Counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Dustin Coons for Cameron Fair. I'm here in the courtroom. He's appearing by Zoom.
Mr. Fair, can you hear us?
Yes, ma'am.
Okay, today was the date and the time that was set for a pre-trial. We got one count for weapons, firearm possession Under influence and count two, weapons, firearm, careless discharge, property damage. How are we proceeding on this?
Yes, Your Honor. I've spoken to Ms. Petrosky about the case. There is a plea offer on the table. I think this particular case presents some interesting legal issues, though, that if my theories are right, I don't believe the prosecution could move forward. So I'd be seeking a motion date and final pretrial date to court.
And what's the offer?
The offer is for Mr. Fair to plead guilty to count two, careless discharge or property damage for $50 or less of a firearm, and forfeit the firearm, and we would dismiss count one, the possession under the influence.
And I believe there would also be a
Oh, yes, excuse me.
recommendation.
Yeah, and as well as a sentencing recommendation for no upfront jail.
Okay, and when do you intend to file your motion?
Your Honor, if I could just get a motion date, that will help me get on track to. I don't need much time to draft it, I think. So,
If I get it, I gotta give her time to respond.
of course,
And I gotta have time to
of
read it.
course.
Because I typically get a response the week it's due. Like people, guess I sit around waiting for responses. So that's why I don't know how much time you need to file it. But if you don't need much time, we'll get you our next court date.
That is June 18th at 10:30.
June 18th at 10:30. I expect that there will be a motion filed that gives her 14 days notice or time to respond.
Do that, Your Honor.
Okay. Any additional matters for today's record?
I don't think of people.
No, thank you, Your Honor.
And you're gonna have a hearing date, but your client doesn't live here, so he's gonna appear via Zoom for that hearing.
If the court would allow it.
You need a final pretrial as well, correct?
Yes, sir.
I'll put that after the June 18th date. Final pretrial, July 9th at 8 a.m. July 9th at 8 a.m. for final pretrial. The defendant and the victim can appear via Zoom.
Here. And trial August 6th at 8.
August 6th at 8. For jury trial, parties must appear in person. Additional matter for the record?
Nothing from people.
As a point of clarification, I don't believe our motion will require an evidentiary hearing. That's what I think right now. Ms. Petrosky may end up disagreeing, and I may change my mind. So indicated in the motion.
Okay, sounds good. No problem. Any additional matters?
Nothing from people.
You're all set. We'll get you a notice to appear. On the record in the matter, the people of the state of Michigan versus Eduardo Domingo Alejo, file number 24-00573, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Jacob Riley on behalf of Mr. Alejo.
Okay, today was the date and time that was set. A trial for one count of domestic violence. We need to proceed on this.
My client would ask that this matter be set for final pretrial and trial dates.
Well. Was set for final pretrial before he was in Stonecrest, is that where he was? Witness appear?
The witness did as the last court date, which was on May 7th.
Okay.
So she was excused from appearing today.
I have a note here that did not need to appear, so this matter will be set for jury trial.
Thank you.
August 13th at 8 a.m. in person at the court. You have any questions today, sir? Any additional matters for the record, counsel?
Nothing from people.
You're all set, sir. You will put power. Let's see, that's it. Back on the record in the matter of the people of the state of Michigan versus Jimmy Tottenham. Counsel. And Mr. Lee, your request was for permission for her to go to the address of 3017 Forest Road
That is correct, Your Honor.
for the purposes of doing what?
Retrieving personal property that she has in the home. That is the home that they were sharing prior to the allegations. Upon the issuance of the no contact order, Ms. Cottenham did not go back to the home and retrieve those items. And if you've read the message, then you know he's going to be leaving that property, will not be leaving there, or rather living there anymore. So he's got to be out in a couple of weeks, and he said this weekend, Memorial Day weekend, would be a good opportunity for them to come pick up her stuff. She has a church group that is volunteered to help her in that endeavor.
He said he'll be here Memorial Weekend.
Yes, he'll be there on Memorial Weekend and available to assist if anything is
Assist who?
necessary. I think what they really need to do is just call him and let them know what time they will be coming there so that he can make sure it's open and available to them. And I think he should leave the property, let them get the stuff, and then, or have the police there or whatever, you know, logistics need to be worked out. But I agree with you. It would not be appropriate for him and her to be there at the same time.
Has your office been in contact with them?
Let me pull up, but I believe, yes, we have. I know we haven't spoken specifically about this issue.
Okay, well, I'm going to require the prosecutor to reach out to him. I don't know who this text message is from. I can easily put a number on my phone and said it was from anybody. So I need the prosecutor to verify that he, A, is okay with not being there so that she can go get her things, or that he can work with a third party for the purposes of getting her things.
And I don't, I haven't dealt with this specific issue since I've been in Ingham County, but I know in other counties, it's been standard practice to have an officer go with the individual to go retrieve their property on civil standby. So I would just after obviously I confirm everything with the victim, if that's how we're gonna
Yeah,
proceed.
that's typical in their bond conditions. I don't know if I didn't arraign her, so I don't know. Let's see if that was in there. That was not granted and it's part of her bond conditions. However, if you can confirm that he's not going to be there, this message, at least what I've seen, says it's from April 1st.
Yeah, I will confirm that and then I will notify Mr. Lee in court.
Okay, you let me know and then I can amend the bond so that she can go one time with law enforcement to get her things, or he can confirm that he won't be there. You can also ascertain if he intends to come to court for our next court date, so we're not wasting people's time. If he's not, then we can free her of her life. He doesn't need to tie up the court. But he can't hold this over and call the police for bond violations and then send text messages too. We can't do everything. So I'll let the prosecutor do their due diligence to flush that out, and they can notify me and we'll handle it accordingly. Any additional matters for the record?
Nothing from the people.
Nothing for defense, thank you.
You. Attorney. Okay, on the record in the matter of the people of the state of Michigan versus Anthony Devon Price, file number 23-03212, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Jacob Riley on behalf of Mr. Price.
Okay, today was the date and the time that was set for sentencing. I do have a pre-sentence report and recommendation dated prepared May 10th, 2024. Counsel, did you get a copy of that?
No, we didn't run against.
Yes, Your Honor.
We need to make changes, update to resolutions.
No, Your Honor, I believe the report is accurate. I know.
No edits from from
Make allocution.
Your Honor, I think the recommendations of the report are broadly fair and reasonable. I think perhaps the fund would benefit from conflict resolution and or anger management counseling. Certainly, he separated himself from the kind of contentious situation he had with his neighbors, and it's not a situation he wants to be in ever again. I think this is going to avoid that. I don't think you're going to see in this court this sort of issue again. And going forward, I think he's committed to sort of developing better ways to deal with conflict and interpersonal issues in his life.
Thank you. Did your client want to make a statement at all? What's going on with these pending detainers warrants? Make a statement about that.
Insurance on my car.
Yeah, what's going on? Did you pay it?
I'm just going through it. It's been a lot going on. Trying to be back on my feet.
Are you working?
All right. I'm trying to find a new job, but it's kind of hard finding a job when I'm disabled.
You say you're on dialysis? Okay. Because you were working, I thought, previously, at least at the time of the election incident.
Yeah, I was, but this case made me lose my house. Pretty much everything.
Because it says you have some warrants in 64A, 65A.
So I think
And they're willing to pick up within 50 miles. So they want their money. So what are you gonna do about that, sir? I understand that you have some health conditions, but you also have some children and some legal matters, which if these were set for show causes, that means they've been lingering for a while. You gotta make some kind of communication with that court and a payment arrangement of some sort. You can't just let it linger and anything can happen. You make police contact, then you're in jail because you owe money. You don't want that. You call and you say, hey, I got this failure to appear for show cause. Show cause just means you come and show us why you didn't pay. I lost my job. I have a health condition that's preventing me from getting gainful employment. I need some time. It requires you to take responsibility to make that communication so that you don't walk out here, make unexpected interaction with law enforcement, and then you're picked up and transported 50 miles away because you owe a fine. Okay?
Where is it located? I don't even remember.
64A and 65th A. I couldn't even tell you where those courts are. I'll let your attorney look those up.
It looks like 64A is Iona and 65A is Clinton County, St. John's.
Well, it looks like you gotta pay, you didn't pay a fine from there, that's what it's saying. I don't know that you can say you've never been to St. John's. I have one here, 10/29/2018, in your criminal history report, that you were allegedly charged with the domestic violence in that county. It was dismissed or nollied, but you were at least charged. Oh, now see how that refreshes recollections, right? Yeah, and then 64A, June 22nd, 2021, misdemeanor motor vehicle operate without security. You pled guilty. You didn't have insurance. That's what you say. You didn't have the insurance. That's what that one's for. So you owe them some money. And these are kind of old. They want their money. And you got to make arrangements so that you don't get, because 65, they said, whereas 64 is willing to pick you up within 50 miles. 65 said, we'll give you 100. They want their money. So you're gonna need to find something that you can do part-time, whatever, because you still gotta make a living for yourself and for your children, which your children were the basis of your defense in this issue, correct? that you were protecting and providing for your children. And so you still need to do that. I remember the trial. I found it to be an unfortunate series of events. But the jury made the decision that they made. And so regardless of the circumstance that you may be placed into as a father, you still have a responsibility to follow the law and to resolve matters in ways that comport with the law. Even if you believe that you were sufficiently provoked. Nonetheless, I believe that you would benefit from participating in an anger management program, but I think you would benefit most by getting a job.
Yeah, I ain't even got no anger problem.
I would say that a reflection of your criminal history does not necessarily agree with that. There has been at least 2 other charges of assaultive action, no conviction, but charged.
Yeah, that's good.
But I don't want to hear anything about what that's because I also know from the vantage point that I have that lots of domestic violence are charged, but victims don't appear for various reasons. A lot of times they didn't got back with the person that they had the alleged domestic violence against, or they just don't feel it's worth it. Either way, you have been at least charged with assaultive actions on more than one occasion in different years, 2018, 2021, and then now a conviction of an aggravated assault, or an assault and battery, I should say, in 2024. And so you would benefit from some resources and tools to help you to avoid having further charges brought against you for similar action, don't you think?
I have an appointment with this rehabilitation center. I think they can try to give me a second. I guess that's what disabled people work.
You have an appointment where?
We have some rehab center. On June 6th.
You don't know what the name of the rehab center is?
No, I just know it's a rehab center.
Okay.
I don't do drugs, man. It's just like that.
You're going for a job placement? Is that what you're going
Yeah,
for?
they're gonna send me the paper. They'll try to send me the paper.
Okay. And you're on disability? Is that a yes? I'm going to order that you complete an anger management program and provide a proof of that to the court within 60 days. And bring proof that you've been looking for an employment. I'm not going to put you on probation. I just want you to do the anger management. I'm going to give you a date for you to come back for that. Give me 60 days, please.
July 23rd.
July 23rd at 10 a.m., okay? Okay. Do you have any questions?
No.
Any additional matters for the record?
Nothing for the people.
Nothing from the defense room.
Just so we're clear, I haven't sentenced you yet. I reset the sentence for that, for you to do that. Come back without it and see what happens. Have a good one. Terrence Hawley. On the record in the matter of the people of the state of Michigan versus Terrence Javante Maurice Hawley, file number 24-01357, council appearance.
Assistant Prosecutor Pete Petrosky on behalf of people.
Jacob Rowley on behalf of Mr. Holly.
Okay, Mr. Hawley. How are you? It was the date that was set for a pretrial. This is for domestic violence, but now I have a bond violation. Allegation that you violated the terms and conditions of your bond by making contact against the no contact order protecting Jessica Redmond. So you have the right to have a contested hearing on the bond violation or the allegation that you violated your bond. You have the right to be represented by your attorney at that contested hearing. If you're found to be in violation of your bond, you're facing 93 days in jail and or a sentence of $7,500 in fines. Do you understand that? So you want to address that.
Your Honor, Mr. Holly will plead guilty to the violation.
Is that correct? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, so you do understand that you do have the right to have a hearing on that and require proofs to be brought forth that would sustain the violation that you don't have to plead guilty. Do you understand that? You want to waive your right to the contested hearing and enter a guilty plea to the violation? Anybody threatening you to do that? Any promises being made to you if you plead guilty to the violation? As to the violation, that you violated your bond conditions, say on or about May 10th, 2024, by making contact with the protected party. How do you plead? Actual basis.
Mr. Holly, is it true that you were arraigned on May 4th of this year for a misdemeanor case? Is it true that you were placed on bond? It was one of the conditions of your bond that you were not to have direct or indirect contact with Jessica Redmond. Is it true that you violated those bond conditions by having direct contact with Jessica Redmond on or about May 10th?
Any additional questions?
No, Your Honor, thank you.
Okay, the court is satisfied with the factual basis. I'll accept your plea to the bond violation. I find it to be freely, voluntarily, and intelligently made. Is he on remand because of this?
Partly because of this, Your Honor, but he also has a pending circuit court probation violation set for a hearing on Thursday, the 23rd. Sorry, Wednesday, the 22nd.
Well, how are we proceeding in the underlying issue?
Mr. Holly also has a felony case that's being handled by Assistant Prosecutor Mr. Adam Pfeiffer, that I believe is in the process. It's in the early stages. It's still a district court. So at this time, there's not an offer in this file, but it's my I anticipate that this case will be wrapped in as a form of, or as a part of a global resolution with that file.
So how do you want to proceed?
In light of the possibility, or I should say likelihood that the case to be arraigned and set for court dates in the near future, I would request a second pretrial conference on this case.
25th. 10. June 25th at 10. You can make allocution on sentencing for the bond violation.
Your Honor, certainly, Mr. Holly exercised poor judgment by violating the conditions of his bond very soon after his arraignment for this case. I do want to note that to my knowledge, at least, there is no allegation of any kind of assaultive, threatening, or harassing behavior attached to this violation. Mr. Holly certainly needs to be aware and be careful about abiding by those bond conditions. Certainly, if the GPS tether were to be ordered, he would not have a problem with that. But certainly, he has been in custody for a week on this matter. He has that circuit court probation. Request that he be allowed an opportunity for pretrial release.
This is not a bond violation. This is a sentencing on a bond violation. This is not a motion for his bond. I don't care what he would be open to. He was supposed to follow the court order. I don't care if the contact is not alleged to have been assaultive or threatening. We didn't say that you're not allowed to have any assaultive or threatening interactions with the victim. We said no contact at all. And you violated it. What is supposed to make me believe you're not going to further violate the court order when less than a week goes by and you're already in violation? What's he on probation for?
I can pull that file up. I don't have it open at this exact moment.
But you got an alleged violation? What's the alleged violation?
This is for failure to report for the month.
He doesn't follow court orders. Sentenced to 30 days Ingham County Jail on the violation. Bond in the underlying matter will now be 500 cash shorty with GPS tether. And you're not to be within 2,000 feet of wherever the victim is. You're not to have contact of any kind, of any nature, directly or indirectly. Do you understand what direct contact and communication means? Do you understand what indirect contact and communication means? We'll see you at your next court date for your pre-trial, June 25th at 10 a.m. Any additional matters for the record?
Just what was the bond amount modified to?
500 cash shorty
Thank
with
you.
GPS tether.
And then nothing further from people.
Nothing further.
You're all set. I have to go back and price this class. Benjamin Riddle.
Your Honor, I received a message from Mr. Riddle's father this morning, indicated that Mr. Riddle had been assaulted over the weekend and was taken to the hospital. I don't have any further updates as of yet.
He's already on baseball. Okay. He failed to appear on his last court date. My last note was April 22nd. Revoke bond, remand to see judge because he failed to appear.
That was then charged. Well, I put him in work today because you told me to, where he didn't charge a GPS setter.
Yep, that was on the 22nd.
Yeah.
I haven't got any notice that that was fixed, so he's already on, his bond is already revoked.
Okay. Thank you.
Wilbur, Mr. Green reached out yesterday, just saying that she's in Newton County, so. She needs to.
County,
June 18th.
I think you got 26.
May 21st.
Oh, this one was saying 26.
Oh,
never
sorry.
mind.
Oh, huh? I was gonna say, I swear.
Okay. Hold on.
Because she still has to leave up in the circuit court, right? Oh, okay,
Diana Zimmer,
then.
didn't appear.
Yeah, okay, yeah.
What happened to Diana Zimmer?
Yeah, once Judge signs this out.
Trying to get some special dog service. Miss Zimmer. Do you have her number?
And a number, but it appears to be on the surface.
Boy.
Yeah, let me do a second. I got a couple cases that I'll need downloads for
For the,
Kaylee to it out, yeah.
okay, I can,
Get the case numbers, just when you're ready.
they're in the docket, I have.
Oh, okay, perfect. And there's one though. Isn't gonna rank one of the retail frauds, but that one, we're not sure, so. There's no court record for that, but I'll let you know once I officially dismiss it in our system.
She's a senior citizen. This is a dog at large case. I'm gonna reset it. I cannot in good conscience bench warrant her for that. She might have forgot.
I am here.
Who's I'm looking for Miss Zimmer.
Not me, sorry.
Okay, thank you. We'll send her a notice and maybe she'll come. So, Mr. Riley, we're gonna send her a notice and see if she comes. Who's TMO's iPhone?
Judge.
Hi, Mr. Blackman.
Good morning.
Okay, and then someone is on, it says TMO's iPhone. What's your name? Name. Hey. I'm sorry?
Amir Jernigan.
Oh, okay, thank you. Who's representing Mr. Jernigan?
I am,
Do you need to speak to him?
I think we're ready to go on the record.
Okay, and then Mr. Blackman, are you ready, Ms. Davies?
I believe so, Judge. Can I have a breakout? I was just looking at an email from Paige, so if I could talk to my client real quick, I would, on a breakout, I would appreciate it.
Okay, 1 second. Our comedy date for Zimmer. June 25th. June 25th at 9. Then, let's see, on the record, in the matter of the people of the state of Michigan. First is Amir James Jernigan, file number 24-01105, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Jacob Rowley on behalf of Mr. Jernigan.
Okay, Mr. Jernigan, today's the date and time set for pretrial. I got count 1, domestic violence, count 2, assault and battery.
Yes, ma'am.
Okay, and then you do have counsel now. Was there an offer on this, prosecutor?
Yes, there was. If Mr. Jernigan were to plead guilty in count 1, people have no objection to 7694A status if he's eligible, and we would dismiss count 2.
Pretrial. August 13th. 13th.
Yeah, I saw that.
Okay, your final pretrial is going to be July 9th at 8 o'clock in the morning in person at the court. Jury trial is currently scheduled for August 13th at 8 a.m. in person at the court, okay?
Yes, ma'am.
Do you have any questions today?
No, you said this is in person and it says June the 9th, June the 8th, July 9th.
Yep, July 9th is in person and August 13th is also in person.
Okay.
Any other
Yes, ma'am.
questions, sir? Okay, unless
No,
you have
ma'am.
any, well, then you're all set. Thank you.
Thank you.
You're welcome. Mr. Okay, Mr. Blackman, are you ready?
We are.
Okay, on the record in the matters of the people of the city, I'm sorry, people of the state of Michigan. I saw the dog licenses and it messed me up in my head. File number versus Jocelyn Davies, 24-00433, 24-00434, 4 and 435, and 436, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Your Honor, Fred Blackman on behalf of Ms. Davies.
Okay, today was the date and the time set for pre-trials. I have a dog malicious destruction of property and 3 dog at larges. How are we proceeding?
Your Honor, if I might, I received from Paige a plea offer. My client will be pleading guilty. My client will be pleading guilty to one of the counts of dog at large, pay restitution if there's any restitution. That's my understanding. The other counts would be dismissed.
Okay, I don't know where your client is. It should duck. Of course, it doesn't mean you.
I'm sorry,
And you also don't
I'm
get
at
to
a
talk
field
over
trip.
me. You also
Oh,
don't
sorry.
get to talk over me in virtual court either. And so you need to be stationary and ready to proceed with the trial. Your attorney is advising that you're going to take a guilty plea to a criminal action. So you probably don't want to be talking to someone else right now. Okay? Okay. So she's going to plead to what, counsel?
One of the dog at large counts, Your Honor.
That's correct. Yes, she'll be pleading to one of the dog at large counts and agreeing to pay restitution. I've tried to contact the victim to get a number or an amount for the restitution, but she wasn't able to, or she didn't pick up when I called. So I will be trying again to get that restitution amount, and I'll be getting that to Mr. Blackman as soon as possible.
Thank you. Thank you.
So we need to set that for a restitution hearing.
That's correct, Your Honor.
Any particular dog at large count that you needs to plead to?
The people have no position on that.
Okay, Ms. Davies, you can unmute your device. You want to plead guilty today to one count of dog at large and pay restitution?
Yes.
Okay, and as a way of agreement, the other charges will be dismissed?
Yes.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, so you can put your hand down. You have several rights that you need to first understand and that you will need to give up in order to accept this offer. First, you have the right to the presumption of innocence. You are presumed to be innocent until proven guilty. Do you understand that?
Yes.
You have the right to require the prosecution to prove your guilt at a trial. You have the right to a jury trial. You have the right to remain silent at your jury trial and not have silence be used against you. You have the right to see, hear, or question any of the witnesses that the prosecution calls to testify against you. You have the right to call your own witnesses to testify on your behalf or present evidence that you believe show a defense to the charge being brought against you. You can waive your right to silence at trial and testify on your own behalf. You understand all of those rights and you're willing to give all of those rights up today?
Yes.
Threatening you to get you to plead guilty to one count of dog at large?
No.
Has there been any promises made to you if you enter a guilty plea?
No.
And you're agreeing to restitution being paid in this case, but you don't know how much the restitution is. Is that correct?
Yes.
Okay. And so we're going to set it for a restitution hearing, and to the extent that an amount comes in that you disagree with largely, then we will address it by way of hearing. As it pertains to file number 24-00436. Dog at large, how do you plead?
Guilty.
Factual basis, please, counsel.
Thank you, Your Honor. Ms. Davies, let me take you back. Let me take you back to on or before March 5th of 2024. Were you in the city of Lansing County, Bingham, state of Michigan?
Yes.
You owned at least how many dogs did you own?
4.
4, okay. On that date and time in question, did your dogs break out of your fenced yard?
Yes.
Okay, and they were running at large in the community at that point, is that correct?
Yes.
How long were they out? Do you know?
20 minutes, if that.
Okay, but they were running at large and they were not penned up as they're supposed to be, is that correct?
Correct.
All right, yeah, I have no further questions.
Any questions from the prosecutor?
No, Your Honor, thank you. And I know Mr. Blackman's not present, but I do have a plea sheet filled out for this.
You can sign, I give you permission to sign my name to it.
Oh.
Thank you.
Thank you.
Oh, no, via Zoom. Okay, and so we'll set this matter for sentencing and restitution hearing. June 25th. June 25th at 9 a.m.
Thank you, Your Honor.
You're welcome. If we're gonna have a hearing, your client must appear in person.
We will be in person, Judge.
Okay.
Does she need to go to the probation department at all, Your Honor, or just appear for the hearing?
Nope, she does not. I'm not referring her to probation for a dog at large.
Okay, thank you.
Thank you. Any additional matters for the record?
Nothing from the people.
Nothing for the defense, Your Honor. Thank you.
Thank you. You're all set.
Thank you.
You're welcome. No, I don't need to bring up Thibodeau. Did we take a plea for Thibodeau already? Is that what happened? I don't remember.
Thibodeau's case is being transferred into the drug court, and so
They take a plea there. Is that
yes,
correct?
yes.
Okay, yeah, we don't need to bring her up. I just need Judge Ward to sign this on behalf of Judge Cannon, and then that case will be all set today. And then,
So the rest of the day is fine.
yep, this is Miss Berkeley. We have Jernigan here, or Armstrong. Last name? You're Armstrong. Where's Mr. Yang? I saw him. Well, you find. the matter of the people of the state of Michigan versus Cheyenne Armstrong, file number 24-01376. Council appearance.
Prosecutor Pete Petrowski on behalf of the people.
Good morning, Your Honor. Joseph Yang on behalf of Ms. Armstrong, is president to my right.
Okay, Ms. Armstrong, today's date that's set for a trial, one count of attempted police officer assaulting, resisting, obstructing, count 2 retail fraud in the 2nd degree. Is there an offer on this?
There is, Your Honor. Our offer is for Ms. Armstrong to plead guilty to an amended count 1 of disorderly person jostling with no objection to HIDA, and we will dismiss count 2.
Your Honor, I have extended the offer to Ms. Armstrong. She'd like some time to review that. And so I'd ask for a final pretrial be set. I don't believe there are any other pending discovery issues at this time.
I'm not requiring a witness to come, so we can set it for a final pretrial. But
Yeah, yes, Your Honor. I guess I wanted to set the final pretrial as kind of a deadline for the offer so that we know how we're gonna go with this
Sounds good.
case.
June 25th at 8. June 25th at 8 a.m.
That works for me. Thank you, Your Honor.
You'll appear in person for that, and then you'll have time to consider the offer and discuss that further with your attorney. Do you have any questions for the court today? Any additional matters for the record, counsel?
Nothing further from the defense, Your Honor.
Nothing for the people.
Okay, you're all set.
Thank you, Your Honor.
you.
I didn't know I was supposed to say something. Were you waiting for a case?
Yes, Your Honor.
Which one?
That's a probation violation, or excuse me, a bond violation.
Oh,
I didn't see there, so.
were you with her, sir? Were you waiting for a court date? Oh, that's Mr. Smith. Okay. We need Mr. Seabrook because he's my entire 1030 situation. And then Susan. Smith. You're representing Mr. Smith?
No, Your Honor, this is one of the conflict counsel, unfortunately, is doing that.
That's right, because you represent the co-defendant. So we have to reset this. June 25th at 10. Get you a new court date, Mr. Smith. By then you should have had new counsel and should have met with your counsel, okay? Do you have any questions for the court? Oh. Does he have an attorney? Are we ready on his matters?
Close, Your Honor. I'm waiting for an email to come through.
Mr. Hero.
So, just send me some clears I can receive.
22.
Oh, and then I'm just because we have a dog. Is this
I did.
Houston or is it
Yeah, 2026.
Zero? Okay, cool. Because that.
Okay.
But I don't know.
Zero five. Yeah.
We just like
The numbers went up.
email, text message from somebody like, hey, yes, I did have this dog now, just so that way I have something for a file.
So,
Okay. Oh,
So just put 26.
That
instead of
yeah, because
2026.
yeah,
yeah, you don't have to put the whole.
I need them before Christmas, but I'm
so I just trying to see.
Joshua Zuzman,
Indirect or direct.
So do not have contact.
no Joshua Zuzman. Of course, it's a dog case.
Did you do a benchmark for Devin Rainey?
Who?
Devin Rainey, it's another dog case from this morning. He was set for 8:30.
Not on my docket.
Oh, maybe something got changed.
I was gonna say, all these, this is all I got for the rest of the day. And these all belong to Mr. Seabrook.
Page down.
Oh, yeah, no, you're supposed to get moved. My bad. What's up?
Oh, I'm sorry.
Oh,
I'm showing how to do this, Bart. I'm sorry.
no, you're good. I do that all the time. Sorry about that.
Okay, click one, you can push. They live. What is GPS tell you? So. Hold on, I'll show you how to do it. Go back for that. So.
Get that next one. Yeah, you can put. You can put GPS on it. And that's it. So that enter again, and remember F7 4 times.
What's the word? Let's see. It's kind of like this.
Like you probably hit it. It must have shown 17.
Go through all that. Here we go.
Taking pictures.
That what happens. You just, sometimes you gotta clear the queue out. So you would just go back to there, hit the 3, clears it out. I don't know why. I hit that first. You must be.
Here's some.
Hopefully we.
That's right here.
Oh, see, that's what I'm talking.
We're prepared to proceed. Mr. C, with whatever you.
Thank you.
March.
Not something. If that helps, keep track of.
Another one, but they can't find it, so I just have to print them.
Yeah, I think it's two.
Oh, you both, okay. There's a couple. Yeah. Okay.
Thank you. Oh, looks like he took it yesterday.
Oh, this far, let me,
Right.
A violation for.
Just pre-trial, so
Oh,
that top part is hard.
That was just.
Yep.
okay, that one I should deal with later. Okay, on the record.
Yep.
The matters of the people of the state of Michigan versus Perry Alonzo Seabrook, file numbers 23-0, 3281, 3282, 24-00608, 609, 610, 24-01023, 1178, 1179, 1180, 1181, 1182, 1183. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Assistant Public Defender John Lee appearing on behalf of Carrie Alonzo Seabrook.
So, Mr. Seabrook, today's date set to address 1, 2, 3, 4, 5, 6, 7, 8 dog at large and 1, 2, 3, 4 dog license vaccinations. Council, how are we proceeding?
Your Honor, at this time, Mr. Seabrook has begun producing the proofs necessary to come into compliance. He has showed me pictures of remediation that he's making to cure the dog at large charges. He has also showed me 2 out of the 4 licenses. However, I have not yet had a chance to review the licenses, just received them. And of course, we need proofs on all 4 of the dogs before the prosecutor would feel comfortable dismissing. So we probably need a short adjournment to complete the proofs and resolve the issues.
So we need to recess, please. June 25th at 10:30. Yeah, at 10:30 is your next court date, okay? On these files.
Thank you, Your Honor.
Say, hang tight. You're gonna stand there while I write this note in every single last one of these files.
Yes, ma'am.
People of the city of Lansing versus Harry Seabrook. He was supposed to be here yesterday. What happened?
I was thought everything was staff at all.
I could totally understand why you would be confused, why there would be 20 cases today and one yesterday. I could totally get that. This has to be reset. There's the reason why this was yesterday, so this one's a city case. So a city attorney has to be here. She doesn't work for the city. She works for Ingham County Prosecutor. So we don't have a city attorney to address this. This needs to be reset to a city day. So you can't confuse your city court dates with your county court dates, okay? June 24. June 24. 9:30. At 9:30. Back-to-back dates, okay?
That's right.
And what's your name?
My name's Kelly.
You also remember his court date?
Yes.
Maybe you're not. On the record in the matter of the people of the state of Michigan versus Carrie Seabrook, file number 24-01395 SM, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Carrie Seabrook.
I have a misdemeanor complaint here that alleges that on or about April 12, 2024, at the area of 829 Euclid Place, City of Lansing, Ingham County, State of Michigan, that you did allegedly commit the act in count 1 of domestic violence. It alleges that you did make an assault or assault and battery upon a Kelly Hooks, an individual with whom you had a dating relationship, contrary to MCL 750.812. That's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fine. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the charge and the maximum penalty. You have the right to be represented by counsel. Mr. Lee, who is representing you on other matters charged before this court, is only here on this matter today for the purpose of your arraignment. You do have the right to have an attorney represent you at each stage of the criminal prosecution and if you're questioned by law enforcement, okay? If you can't afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public because you are being represented by other matters, on other matters by the Office of the Public Defender. I'm inclined to believe you would be eligible in this matter. Are you requesting representation? I don't know if that here on the file. You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. If you stand mute, this matter is going to continue to trial. You have the right to jury trial and you have the right to the presumption of innocence. You're innocent until proven guilty and you have the right to require the prosecution prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to confront and cross-examine any court any witnesses this prosecution calls to testify against you. You have the right to remain silent at trial and not have silence be used against you. You can waive your right to silence and testify at your trial if you like. You can subpoena witnesses to testify on your behalf at your trial, and you can present evidence that you believe show a defense to the charge being brought against you. Do you have any questions about those rights? For the purposes of your arraignment, the court will enter a plea of not guilty. The matter will be set for a pretrial. Before me, June 25th at 10:30, which is the same date as your dog cases, okay? I need to spell history.
Yes, CCH on this.
Yes, please. You can have a seat. And counsel, you can get whatever his belongings that she has because you know there's going to be a no contact order.
Susan.
What does the doggone fund trip mean? Oh, okay. I thought that was like a business or something.
Oh, it is.
Oh, okay. But you're not connected to that business. You just thought it would be fun to wear to court. I would wear something like that too if I had 20 dog at large cases before the court at one time.
I did too.
Excuse me. Good Lord. This afternoon, we have 2 probation violation hearings. Would it be okay if I appeared via Zoom for those?
Are we having hearings?
And they're set for hearings. I don't anticipate they'll be contested. One of them is Mr. Hobtolem.
Now the other one is non-public, so.
Oh.
Let's see.
I'll double check with council, make sure that they're not contested before.
Yeah, if they're not contested, you don't need to appear.
Awesome, we've got a training for assistance. Okay, and then this. So bad. I think.
Help us, Lord. Okay, well. Please tell me this is on the same citation. It is.
Oh, yeah.
Okay, back on the record. I now have people of the state of Michigan versus Kerry Seabrook, file numbers 24-01467, 1465, 1466. Council reports on this record.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Kerry Seabrook.
Okay, Mr. Seabrook, 3 more dog at larges that you were actually scheduled for an arraignment on June 14th, and you obviously were not aware of that. What's your address?
29.
That's where you receive your mail? In Lansing? What's your phone number?
517-974-5426.
Okay, I have a citation here that alleges that on or about May 3rd, 2024 at 11 p.m. In the area of South Pennsylvania and East Kalamazoo, City of Lansing, Ingham County, State of Michigan, that you did allegedly get cited for 3 violations of dog at large. This is Sarah, 1.5-year-old fawn white, a husky female, Jazzy, 1.5 tan black husky female, gray wolfie, 1.5-year-old tan gray husky, ran at large. Similar to your other matters, you have the right to have a trial because these are criminal offenses. You have the right to be represented by counsel at your trial. You have the right to the presumption of innocence. You're innocent until proven guilty. All the other rights that I went over in the domestic violence apply in this matter as well, as it relates to the right to confront witnesses and your right to bring evidence that you believe would show a defense to the charges being brought against you. The court will enter a plea of not guilty on your behalf. Note that you are requesting court-appointed counsel, and these will be set for a pre-trial on the same date and time as your other matters, okay?
State cases, you're,
Dot at large?
yeah. Sorry, yes.
I think they can
Yeah,
only be
those are
state.
state,
Yep,
yeah.
they're gonna be state, yep. At this point, there needs to be a condition of bond. I might have to order you not to have an animal at this point, just so we can stop having more dog at large cases. Is that what I need to do? I'm talking about if I order you not to have any dogs, that could be a bond condition. I'm sorry? Yeah, well, what do you think that the law will do if someone had children that kept running away and disappearing and getting lost? What do you think that the law would do? Remove the children from the home? Do you think that? Thank you. Okay, let's see here. You have a matter pending in the 37th Circuit Court. No. It just shows that the disposition was that it was bound over. It doesn't show anything else on that, so I'll leave that to your attorney to look into that. Nonetheless, counsel, you can make allocution on the.
Thank you, Your Honor. Mr. Seabrook intends to cooperate fully with the court, as his appearance here today suggests. There was some confusion about the days and times regarding city cases and state cases. I believe that's been addressed today. He is clear and understands that he has to appear on Monday, June 24th, and Tuesday, June 25th. That being said, Your Honor, he has provided me with an alternate address in anticipation of the no contact order for the domestic violence file. And we asked the court to consider allowing Mr. Seabrook to be on his own personal recognizance as these matters are pending.
Where's he gonna live?
He intends to stay with his parents at 6487 Green Road. That is in Hazlet, Michigan. Your Honor.
Not the address. I believe it's on the other file, and it doesn't appear to be getting his notifications there. Excuse me? That's the address we had, 6487 Green Road, Hazlet, Michigan, but you weren't aware that you had an arraignment set on new charges. To receive your mail to that address in Hazlet. Oh, okay. Where are your dogs right now?
8 to 9.
On it said 500 personal recognizance. You're not to be at the address of 829 Euclid. I will allow you to go once to retrieve your dogs and personal items with law enforcement. I reside at 6487 Green Road in Hazlet. We'll send your notices as well. You need to report to all of your court dates. You need to be on time, otherwise it's a violation of your bond conditions, okay? You're not to have contact directly or indirectly with Kelly Hooks while this matter is pending. Do you understand that? You're not to be within 1,500 feet of wherever she is. Do you understand that? You're not to engage in any assaultive or threatening behavior. You're not to possess a firearm or any other dangerous weapon. You're not to use, purchase, or possess drugs unless you have a valid prescription. And you're not to use, purchase, or possess alcohol while out on bond, okay? As to the dog at larges, you must keep your dog secure during the pendencies of these matters. It's your responsibility to ensure they're secure. Do you understand that? On each dog at large will be 100 personal recognizance with all other conditions, including your requirement to appear to all of your court dates, okay? Do you have any questions about your bond? Your next court date, sir? And then what's the one after that? Very good. We'll get you a notice to appear any additional matters for the record.
Nothing for the people.
Nothing for the defense, right?
You're all set, sir.
Yeah. I got some paper, quite a few paperwork that type of things.
I think that's the
So,
main.
yeah, well, let's do the first, this one, yeah. Let's do this. Oh,